This is GRL Raw, the podcast where the GRL team tells you why they're different. Who the hell are they? Why should you want them fighting for you? The industry leader in law with over 180 years of combined experience. This team is here to shed light on crucial topics in law to keep you aware and informed, because it comes back to the primary point. We give a damn.
Oh, we are going. We are up and rolling with episode 8. And back by popular demand, the all-time leading podcast viewership has asked for the dope Yoda to return.
Good to be back. Thank you.
Yes, sir. Yes, sir. We had to bring you back. Your episode is far and away the most popular leading, as you would expect. It's been fun to watch the development and then to watch that first episode. And there's been some things that have happened since then, as is the practice of law.
For sure.
That we're going to want to follow up and address today. But before we do that, we always kind of do a firm update. Hey, what's going on? What's cooking? What's cracking? Got anything? Any big news? Any things that we need to know about?
Yeah, we took a very difficult 6-count felony aggravated misdemeanor case to trial about a month ago, and just got a verdict in on that.
So how did that work? If you did the trial a month ago and you're just getting a verdict in, how does that work? It's not like what we see on TV.
True. So we had to make a strategic decision in this case to try it to the bench, and so
to the court, to a judge. Okay.
Judge is hearing all of the evidence and making some decisions, on important facts and conclusions. And so there was some risk to trying it before a jury because there were some evidentiary issues and some witness testimony that we just thought the court would be better addressed or better handle that issue, and so we went with a bench trial. So tried the case, then had to wait about a month for a verdict. So recently went to that, and on 3 of the counts, not guilty.
NFGs times 3
on 3.
Okay.
The other 3, unfortunately, for the time being, there's a guilty verdict associated with those 3 counts, but they all arise out of a search that we challenged earlier, and so we do have that issue set up nicely for appeal. And so I like the argument. The court's going to have to hear it at some point, and I think that everything falls into place. We could bounce those 3 verdicts.
There's times where you get you don't get the NFG, but instead we call that permission to appeal. Permission to appeal,
and so that so if anything was going to come out of that with a guilty, I'll take the 3 because it's the that issue's just wrapped up very nicely. And so,
all tied to the search of the safe.
All tied to the search. Yep.
Cool. And then Matt got 3 really good rulings. We've been collectively working on the use of search warrants in OWI cases for normal OWI first, that kind of thing. He got 3 really good rulings out of Boone County that struck that down.
And that issue's been coming for a long time. We've been raising the issue of whether or not law enforcement can seek a warrant for a blood draw in kind of a vanilla run-of-the-mill OWI case. And initially, courts weren't real receptive with that.
That's because of my fault, because I tanked that damn appeal.
I didn't want to say anything, but
call it learning.
There has been slowly gaining some traction, and we get better with the argument, and we modify it depending on what the courts are accepting and what they're not paying attention to. And so I think that now we're coming to the point where that issue's fully framed and ready. And so congratulations to Matt, obviously, but more to come on that.
More to come on that, and then this month is going to be crazy. We're kind of taping this a little early because Corey and I are at least slated to be in a wrongful death trial in Iowa City next week. Matt starts a sex abuse second trial up in Story County next week. It's going bonkers. It's going crazy. Wheels almost feel like they're falling off. We grab them, keep them on. One thing I started last episode was a special segment where we recognize fellow NFG warriors out there that have been doing tremendous work and getting good results. And so I want to take the quick time shout out to Eric Tyndall and Andrew Yeager out of Iowa City. They got an NFG on a murder one on an insanity defense. Those never work. Never work, right?
Of course.
They got it. It worked.
And, and Eric's, if you talk about people that have tried murder, manslaughter cases, Eric has a number of those under his belt. And so, obviously, one of the go-to people in the state for that defense. And, so congratulations to him for sure.
Huge. Him and Andrea both worked it up together. And then also Nina Forcier out of Waterloo. She's been kicking their teeth in out there all year. She got another NFG. I forget the exact nature of the case, but she whomped them. I think she's public enemy number one in the Lou from law enforcement's perspective. So keep it up, Nina. Killing it.
Done.
Yep. So we're going to take a quick break. When we come back, we are going to update and dive into what's happened with pot, what's happened with the dope, from the dope Yoda, since our first episode and coming all the way around to episode 8. Lot going on. We'll be right back.
Colin Murphy defends drug crimes in state and federal courts, from misdemeanor possession to felony delivery and everything in between. With a proven record of beating traffic stops, search warrants, drug dogs, and snitches, he has recovered cash, vehicles, and firearms seized by the Drug Task Force agents. He's the Dope Yoda, streetwise and fearless, with a walk-off home run mindset. If your last encounter with the police gave you joint pain, you better call Colin.
We are back, and we are going to talk about everything updated since the last time we talked about the marijuana, THC, vapes, and our all-time favorite, what we call the Dirty Dawson bill, trash rips, and the friggin' Constitution, right?
Just a few small constitutional issues to sort out today.
Yeah, well, let's start sorting the trash. So last time we talked, we talked about your big win, your big dub with the Iowa Supreme Court, saying no, cops, you can't go rooting through people's trash.
That's right.
We knew they were working on new legislation, trying to plug the holes they thought they could plug, but not so fast, right?
Yeah, why don't we go back to talk a little bit about State versus Wright. So that's the ruling that we got from the Iowa Supreme Court last summer.
Okay.
And Wright was a little bit of a groundbreaking case because for a long time, criminal defense attorneys had been making the argument that their clients had a reasonable expectation of privacy in garbage. And that issue had made it up to the Iowa Court of Appeals in the mid-'80s on a couple of occasions, and it just kind of stayed there.
Let's break that down, the reasonable expectation of privacy in trash. What the process, the procedure that this came about was what? Like, in other words, what are we talking about? Reasonable expectation of privacy in trash.
Yeah, so in State versus Wright, police had engaged in 3 searches of our client's garbage that was placed out for collection at the curbside, and they had searched this garbage without a warrant.
So client takes the trash out, puts it on the curb for the trash man to come take it.
Correct.
And you're telling me law enforcement, the police yanked their trash out?
Yanked it out.
And then sorted through it?
Ripped through it.
Okay.
And then looked for anything incriminating.
That just seems un-American.
Yeah, so the benefit of that at the time was there was a U.S. Supreme Court case, California versus Greenwood, that said under the Fourth Amendment, so this would be under federal constitutional law, that a person had no reasonable expectation of privacy in garbage that was placed out at the curbside for collection. And so since the 1980s, there's been a police tactic to, surreptitiously, under cover of darkness, go wherever they wanted
Trash
to.
panda it.
Yeah, trash panda, rip garbage once, twice, doesn't matter, and then use any information that they get from that garbage rip to then write up a search warrant to get into the person's house.
Okay.
So the original searches were done without a warrant. The whole goal was to get inside the house, because a lot of times they wouldn't have enough probable cause to convince, a magistrate to get inside the house in the first place. They may be working off a tip, maybe it's something uncorroborated, maybe it's a hunch, whatever, but they were able to get into garbage, and there was no problem with that.
Free reign.
Free reign. And so, Iowa faced that issue a couple times, mid-'80s, essentially borrowed the rationale from Greenwood, and then said, we don't believe that there's an expectation of privacy. So Iowa law, under the state constitution and the Fourth Amendment, consistent. Okay, and so that process got back to the Court of Appeals probably half a dozen times over the next 10, 15 years. Each time the attorneys were raising expectation of privacy. Some other states kind of came online, had their own rulings under their state constitution that you had an expectation of privacy in garbage, and so criminal defense attorneys trying to leverage those rulings to convince the Iowa Court of Appeals. It just was a losing effort.
And in what, 2020, 2019, 2020?
So 2018. We start working on the case. And
Dope Yoda says, hold my beer. We got some things to fix.
Right. So we knew that we couldn't take the same approach because it was just proving unsuccessful. And so we brought a different argument alongside of the expectation of privacy, because if the court's going to hear it, and by the court, the Iowa Supreme Court, if they're going to take that appeal at some point, we wanted to have another argument. And fortunately, they accepted the argument that we framed it, that in addition to an expectation of privacy in garbage, that police were committing a trespass. And what was interesting about the trespass argument was that if the police were doing anything without a warrant, searching private property, personal effects, anything like that, with the goal of obtaining information to use in a criminal case, that was a search.
Okay.
And so when they're going through your garbage to look for information to put in a warrant, that is a search. And so searches have to be supported by probable cause, right?
Can't just willy-nilly trash panda your face off.
Correct. And that was the issue that the court hadn't yet seen, which is the entire efforts by the police at that point were searches in and of themselves. They had to be supported by probable cause. And so I think that's what got us to where we wanted to be in terms of arguing it.
My favorite part about that is as you were making that argument, as you were crafting that argument, law enforcement, attorney general's office, prosecutors were like, oh, of course we can, stupid Colin. Like, these crazies from GRL are making stuff up. This is the worst argument ever. And then, well, bam.
Yeah, it was getting no traction, at the district court level. And Wright went up to the Court of Appeals, and they didn't really address the trespass issue too. They acknowledged it, but they said it wasn't a trespass. They had reasons not to apply it, but that's what formed the basis for the application for further review. And so when we get up before the Iowa Supreme Court, I think that's why the majority, ended up striking down that police practice, because not only was it a trespass, the cops were clearly looking for information to use in a criminal case, but they went beyond that, even though they didn't need to address expectation of privacy at that point, because trespass ends up being
a winner
all by itself. But they went ahead and also declared that Iowans under the state constitution have a reasonable expectation of privacy in garbage.
So you effectively ridded us of law enforcement trash pandas. You're like critter control.
So that's almost 4 decades illegal police practice. Supreme Court struck it down as unconstitutional.
Put them in the trap, chucked it.
And so that was, that was a great win for us.
Yeah.
Great win for the client. Great win for the firm. A little bit of a landmark.
Great win for humanity.
Yeah,
leave our trash alone.
Yeah. And not only police. That will stretch. Primarily it focused on police, but when you say that people have an expectation of privacy, then it reinforces those anti-scavenging ordinances, that communities had, like Clear Lake, like in a handful of other communities where they say, hey, you can't go through other people's garbage. Only a licensed garbage collector can do that. And so
it's what you're paying for.
It's what you're paying for. That's the contract that you have. And it reinforces that idea that, hey, that's my property until, the garbage company takes it. And so privacy and garbage.
So that was the end of the story, right?
Yeah, you think that would be the end of the story.
This is my favorite part.
So the Iowa Supreme Court, declares the practice unconstitutional. So that would have been last July, 2021. And then we started to hear rumblings that when the legislature came into session, that they were going to do something to address this.
Because that's how this works, right? The Constitution, the legislature can change the Constitution.
You would think that when the Iowa Supreme Court decides a matter of constitutionality under the Iowa Constitution, that they might be the final say in what is constitutional and what is not.
Well, if I remember, first day of law school, they teach you supreme law of the land is Constitution. Under that comes any other legislative practice, but any law that the legislature passed has to comply with and abide by and obey the constitutional principles.
That's right. And under separation of powers, only the Supreme Court has the ability, the authority to look at a legislative enactment and decide whether or not that's constitutional. And so it was as we're sitting back watching this unfold, we're acknowledging, hey, there is a way that the legislature can do this, and they would have to amend the Constitution. And so, because the Supreme Court's already declared that this is unconstitutional, if you want to say it's constitutional, legislature, you can do that. There's a constitutional amendment process. That is not something that happens overnight.
You can't just pass a new law saying the Constitution now says
correct
anywhere.
Correct.
Okay.
And so
you don't get to redraft it.
And there were lobbying efforts. There were organizations that were pointing these problems out to the committees that were taking a look at this new bill, and a lot of that fell on deaf ears.
They didn't care.
No, they didn't.
They know what they're doing up there.
Yeah, they know exactly who's in control of deciding what's constitutional, and so. Out of the legislature, with overwhelming majorities, and we predict.
That's the scary part. Yeah. Everybody voted. I think it was almost unanimous, wasn't it?
It was near unanimous coming out of both the House and the Senate, and the governor signed what eventually proved to be Senate File, I think 2296.
Okay.
And that is essentially that's a codification of Iowa Code Chapter 80816. So it's the search warrant chapter of the Iowa Code, and they did a couple of things. They said that as a matter of public policy in the state of Iowa, that people do not have an expectation of privacy in garbage. Directly contradicts what the Iowa Supreme Court said.
So they said, all right, Supreme Court, hold my beer. We got this. We're going to fix you. We're going to tell you what the law is.
Correct.
Even though it was a constitutional principle, which they can't, on their own, change.
Correct. Without amending the Constitution, it was our position, and I, as we
settled law.
Yeah, exactly. So we've got the expectation of privacy argument. They also went further than that. They need to address trespass, because remember we took two issues up, and so they've dealt with expectation of privacy by saying there is none as a matter of public policy in the state of Iowa. Now, as to trespass, they're going to say that the curbside garbage is deemed abandoned. And so once you take it out to the corner of your driveway, you've abandoned any property interest in it, any property right, anything like that.
So according to the Iowa legislature, all them guys up and gals up there on the hill under the Golden Dome, anybody could go through anybody's trash, and they could not make a law that says you can't go through people's trash. True?
Correct. So not only could anybody go through anybody's trash, but especially police, because abandonment, it's a legal term of art. As we argued in the oral argument in State versus Wright, the Supreme Court knows what it is to abandon property. If you're being chased by police and you throw away a bag of dope, that you've abandoned that. You can't come back later and say, oh, because you picked that up, I'm going to move to suppress it from evidence. I've got an expectation of privacy in that property.
Yeah, you chuck it, it's gone.
You took it without a warrant. No, you abandoned it. And under those facts, abandoning something that you had in your possession under those circumstances, much different from your garbage at the curbside.
Right.
Because until the sanitation company comes and gets it, I can go back to my garbage. I might miss the pickup. I wheel my garbage back.
I accidentally threw my credit card away. I need to go root through and find my damn credit card. Not that I've ever done that before.
Exactly. So it's not really abandoned.
Okay.
It can't be abandoned. And
So they passed this law.
But it goes further. And
Okay, yeah, sorry.
So they go on to say that it's deemed abandoned and it can't be constitutionally protected papers and effects. Those are, again, terms of art. Those are part of the Fourth Amendment, part of Article 1, Section 8.
Which is Iowa's version of the Fourth Amendment.
Of the Fourth Amendment.
So they attempt to rewrite the Fourth Amendment in Article 1, Section 8.
That's
They
correct.
say, we don't like that, so we're going to make our own constitutional amendment and call it law, even though they didn't have the authority to do that.
Yeah, and we know that that the Supreme Court in Wright focuses on effects, personal property, papers, things that police are looking for. It might be a utility bill, it might be a letter, something that ties you to the property.
Right.
They said that the constitutionally protected papers and effects are abandoned as well. And so it's really interesting that the legislature can come forward and say that all of those things that are protected by the Constitution, plain language of the Constitution, are now abandoned. So, scratching our heads, right? Because who in their right mind would do this?
Well, who in their right mind would do this? And clearly we're just going to sit back and put our thumb in our mouth and say, oh, shucks, they got us, right?
Yeah, and to add one more thing to that, then they go further to say that you do not need a warrant to search garbage. Because that was the outcome of Wright. If you want to search garbage, you have to have a warrant. And obviously the warrant serves an important purpose. You've got a neutral and detached magistrate. Law enforcement has to come and swear out an application, and so it's got to be based on probable cause. And so you're inserting somebody in between police and the citizen, which is important.
Yeah, having that buffer.
Correct. And so Iowa Supreme Court said that's what you'd have to do. You'd have to get a warrant. And this Chapter 808.16 says warrantless searches are now back in vogue. And so they essentially restore that police power that State versus Wright took away from law enforcement. They restore it. And so here's a question for you. So 1847, what does the state put as its motto on the state flag?
Our liberties we prize, our rights we will maintain.
That's right.
Yes.
So when let's talk about that.
I didn't even use my cheat note, by the way. Right here.
Brilliant.
Thank you.
So our liberties we
Should get that
prize.
tattooed.
So personal freedoms, individual liberties, prize. Prize is a very important term. I mean, it means it's highly significant. It's of extreme importance, highly valued. And so look at what the Iowa Supreme Court did. They said that
That's important.
Your privacy with respect to garbage is prized, valued. And our rights we will maintain. We're going to defend those rights.
And if you look, I think a lot of people may overlook this. If you look at the history of Iowa and Iowa law and constitutional protections, 1847, they were forward thinking.
They were.
They were at the front of changes that needed to happen, both socially, both nationally, all over the place. We were making things happen before they were happening in other places. As far as equality, as far as protections of the Constitution, treating all people equally. That started when the state started. That was at the foundation of Iowa.
Yeah, and I think that motto is obviously lost on the legislature because the Supreme Court's given taken that power away from the police, said it was unconstitutional back in 2018 when they ripped this garbage, 2021 when they decide the case, and it's unconstitutional moving forward, right? And so when you look at how we are going to maintain it, how are we going to maintain these rights? Well, let's talk about the role of the legislature. Isn't it to protect rights
Should be.
that Iowans have, that Iowans have been granted? And you've got a situation where Republicans in control, I'll be political for a minute. You've got Republicans in control of the House and the Senate. This is raw. And you have Republicans now voting in favor of big government. This is police surveillance of private issues.
Correct.
And so we've got a privacy issue. big government, surveillance. Okay, so that's what the Republicans are voting for. And then on the other side, you've got Democrats that have been talking about defunding the police and all sorts of issues for the last several years dealing with law enforcement, and then they just want to restore that police practice back to law enforcement.
See, so you weren't all that political. You just chomped on both of them.
On both parties, because that's fair.
Because they both sat back. They didn't sit back. They both jumped on that bandwagon.
Who's prizing the liberties? Who's defending? Who's maintaining the rights that Iowans have? Really, what it comes down to, in general, it's the criminal defense bar.
Damn right.
And in particular, it's this firm, because we take these issues because we're obviously representing a client that has an interest in it.
Sure.
But at the same time, who else is going to be doing the heavy lifting?
Yeah, if you just sit back and say, "Oh, the law changed, so we're screwed."
Right.
Okay, sorry, boss. Right? Sorry, government. You fixed it. Appreciate you clearing that up for us. No, everything.
Yeah, and so it's poor by the legislature.
Yeah.
We should expect more.
We should,
because there's constitutional provisions that are directly on point in terms of what the judicial power is, what the branches can and can't do, and this is clearly an instance of overreach.
So what do we do about it?
So we put the word out once we heard. Okay, so July 1, new laws take effect.
Mm-hmm.
So this was signed by the governor in April. And they've got 2 or 3 months to get prepared.
Ramp up for it. Get their trash bag.
Yeah, they're going to start
gloves
moonlighting as sanitation workers again, right? And so July 1 comes around, and new law takes effect. We were fortunate enough to get involved in a case involving a garbage rip that took place July 6th. So this would be
after.
5 days after the law takes effect. A search warrant was issued based on a single garbage rip. And we got involved with that case, and the case moved along pretty quickly. So person's arraigned, we get the motion to suppress on file, we get it heard. That was about a week ago, 2 weeks ago, and the following day got a ruling on it. And so we think it's probably the first district court in Iowa to address Chapter 808-16, which is the new law that the legislature
BS law.
passed.
They tried to amend
Correct.
the Constitution without amending the Constitution.
And so we're raising a separation of powers argument, and fortunately, district court agreed.
Damn
So
Skippy.
we think the first court
Tossed.
to take a look at it, it struck it down, and
Took the
essentially
trash out.
took the trash out, and ended up suppressing any of the evidence that they found during the search of the house. So at that point, it's up to the state to do a couple of things. One, the state could dismiss the charges, or they could appeal. And we thought, based on everything, how important this issue apparently is to law enforcement, that they would want an appeal to take that up and then have the Iowa Supreme Court say, yeah, the legislature can do that. There's no problem.
Yeah. Right, because that's what they're going to do.
So we were braced for that appeal. We were looking forward to it because even though Wright was a 4-3 decision, I don't think that this decision, when it eventually gets up there, is 4-3, because essentially the Iowa Supreme Court has to decide who has the final say in constitutional issues.
Right.
Is it the Iowa Supreme Court, or does the legislature get to act as a super court and overturn what the Iowa Supreme Court does?
That would completely upset the entire separation of powers idea.
All Iowa Bill of Rights, separation of powers, completely turned on its head if you get a ruling like that. It won't happen. I'll just go out on a limb. I think that's 7-0. I think that even the chief and some of the other justices who did not like the trespass argument, they're not going to sit back and say the legislature can do stuff like
God,
this.
I hope not.
And I think that the state realizes that too, because when the evidence was suppressed, they did not seek an appeal, but instead they ended up dismissing the charges. So
they gave up.
They gave up. Great result for the client, but what that means is this issue about law enforcement ripping garbage under the new law remains alive.
Remains alive. We now have a ruling out there in our favor.
Correct.
But it's not binding on other cases.
Correct. And there may be attorneys, or it may be an issue that some people miss, because you have this short window of time between Wright becomes effective and then the new law is passed, and so maybe people overlook it. You've got maybe people they have difficulty conceptualizing the separation of powers argument and how to advance that. But we think that issue is a winner.
So it's important that people understand we're here to help.
Yeah.
If there's a case like that's coming, done it once, we'll do it again. We'll continue to do it. Don't mess it up.
Yeah, I think that part of we got lucky because we were able to reach out and work with other attorneys who had this issue, and I think continuing to put the word out, because this needs to get up to the Iowa Supreme Court so the practice can be struck.
But it needs to be done right.
Correct.
Ha! Ha!
Yeah.
See what I did
Rights,
there? Right,
our rights
right.
we will maintain.
And right, state versus right. But it needs to be done correctly, and there are ways that it can get tripped up, which actually kind of brings us to the secondary topic. I got to see how much time we have left here.
About 15.
We got 15 minutes, so we got time. One thing that's changed since we talked initially is a ruling came down from the Iowa Supreme Court related to THC. Reciprocity, in other words, out-of-state residents who have medical marijuana cards, and how Iowa can and or will try to treat them going forward.
That's right. We had a fair amount of success raising reciprocity defenses for out-of-state medical marijuana card holders. And so if you have a medical marijuana card from another state, the same Iowa legislature, okay?
Yep.
This would be a couple years back, decided that, look, if we're going to grant Iowans essentially a pass from prosecution for possession of marijuana when they have Iowa medical cannabidiol in their possession, Iowa's version of medical marijuana, that we're going to grant that same protection to out-of-state card holders who happen to come into Iowa with their state's version of medical marijuana, that we're going to give them essentially a defense.
Yep.
That we're going to recognize those cards, and if the state charges them with possession of marijuana, we're going to give you a process by which you can have those charges dismissed. And so we have been successfully raising that reciprocity defense and litigating it on our clients' behalf and getting dismissals for those cases. Recently, however, the case that you were referring to, State versus Middlekauff, the Iowa Supreme Court a few months back issued a ruling in it's a little bit of a different situation, but it was somebody that had medical marijuana out of the state of Arizona.
Okay.
And so Iowa has another defense that's available for controlled substances, and that's a prescription and order defense.
Okay.
We had not been raising the prescription and order defense in these cases. We chose to raise reciprocity because the prescription and order, it's harder to prove.
How are they different?
Well, every state that has a medical marijuana program, the role of the physician in evaluating a patient or issuing a certification, that's really all that they're doing. They may have an examination, they may certify a condition. It depends on how the state's program is set up. But because marijuana is still a federal Schedule I controlled substance, and doctors derive their prescription authority from the DEA, federal Schedule I, Schedule II drugs, it's a harder argument to make because no state prescribes marijuana.
So using the word prescription simply, it's a misnomer.
Like doctors will prescribe you, say, codeine or some other pharmaceutical, and that may be a controlled substance. They're prescribing that to you, but you're getting it through a pharmacy.
You can't go to Walgreens and fill your THC prescription.
Correct.
Okay.
You're purchasing these at a dispensary, and so it's not. You don't really have that pharmacist relationship. You don't have a doctor prescribing it.
Okay.
There's a lot of difference, and it has to be set up that way to stay away from Schedule I.
Okay.
And so, or just federal controlled substances law.
Yep.
Anyway, and there are some legal protections currently that state medical marijuana programs have with federal budget amendments and things like that, and that's a whole other conversation. But we've been raising reciprocity instead of prescription and order because there's no real prescription for medical marijuana in the first place. Now, Middlekauff was a close case. There were justices who said that the order, because it's prescription or order, that the order matches what the medical marijuana certification process
Makes sense.
is.
Yeah.
It does, but it still misses out on that pharmacy making the exchange and stuff like that. And so it's just a harder one to make. So the Middlekauff issue involved Arizona medical marijuana and whether or not that person had a prescription and order defense to possession of marijuana under Iowa law.
So it wasn't straight up reciprocity arguments that you've been successfully making in the past.
Correct. Okay. I think that there were some reciprocity issues raised at the trial level, but once it made it up to appeal, the reciprocity issue was not appealed along with it.
Okay.
And there was also, I think, a stipulation that Middlekauff may have said that the medical marijuana flower that was in her possession was not an approved form that allowed reciprocity to be raised. And so we disagree with that in our cases, but there's some important distinctions to be made between that case. But at the end of the day, you don't really have a full-throated defense of reciprocity before the Iowa Supreme Court. So there are portions of that opinion that touch on reciprocity to make distinctions between reciprocity and prescription and order. The important thing is they recognize that there's a reciprocity defense.
Which is good.
Which is great, but they don't have to decide like the contour of what reciprocity is and the scope of it because it's not before them. It's just prescription and order.
Okay.
But the fallout from that has been the issues that we have been raising on reciprocity grounds. We're now getting pushback because of some of the dicta in Middlekauff.
And some prosecutors in the courts are saying, this is as close of a case as we have on this issue, so we're just going to go with this and not have to dive into the true differences between them.
Correct. And I think that if they do really take a dive in, and this is an issue that we have been raising and will continue to raise, is that if the defense means what the Iowa Supreme Court says it means, one of two available things for out-of-state medical marijuana card holders, if it means what they say it means, then let's look at this. You have to be an Iowa resident to purchase medical cannabidiol.
Correct.
You have to go through a certification process and get a card. There's only two manufacturers for medical cannabidiol in the state of Iowa. And they cannot manufacture a product for sale outside the state of Iowa. And the product, before it's placed in the stream of commerce, has to be tested in Iowa by the state hygienic lab. And so if you take a look at all of those factors, how can somebody who's not a resident of the state of Iowa, who's coming from outside the state of Iowa, how can they bring medical marijuana products into the state and ever raise that defense?
Yeah, so if you take it to the logical extreme of the way they're trying to apply it, and by them I mean the prosecution, law enforcement, it's impossible to have a reciprocity defense.
I think it's impossible because medical cannabidiol under Iowa law is really a creature of statute. It involves cannabinoids tested by the state lab, approved by the Board of Medicine and the Department of Public Health. It's very unique. You're not going to find that substance anywhere outside the state of Iowa.
Yeah.
But we know the defense is there.
Because they say it, and if you're going to give any effect to what the legislature created, a defense for reciprocity, you really have to interpret it the way that we're arguing it to be interpreted. Otherwise, that whole law means nothing.
Correct.
They wrote a bunch of stuff for no good reason.
Exactly, and we know that if you have to, I think, interpret this defense a little broadly because it's essentially a criminal statute, a criminal defense, and so there's rule of lenity, there's all sorts of other arguments that can be made, but the reason that this is important is a lot of states have medical marijuana flower as their
the bud
medical
Remember
marijuana.
that from episode 1.
That's right, and the administrative rules in the state of Iowa for medical cannabidiol, the Department of Health, they recognize that medical cannabidiol, which is the Iowa product, and marijuana for medicinal purposes are the same thing. So they recognize it in the administrative rules that these other states are providing something. And I think that if you look at it the way that we've been advocating it, it leads to only one conclusion, that you have to interpret medical cannabidiol for out-of-state people to be something other than just the product that's for sale for Iowa residents.
But currently, out-of-state residents who want to bring their medical marijuana into the state of Iowa, they do technically run the risk of the law being interpreted differently and them being arrested, being charged, and having to defend this, which is where obviously we come in and you come in.
That's right.
But that's a legitimate risk, especially now.
It is. Before, I think we could say with some confidence that we've addressed these issues and we've got the better argument. Then Middlekauff comes along. And so now, until this argument can get before the Supreme Court to decide the other half of that, the other defense, reciprocity, that I think people are at risk.
Yep.
So unless you come from a state that is exactly like Iowa and has a extract program that's exactly like Iowa, and the definitions of your medical marijuana extracts and medical cannabidiol are the same, I think you run a huge risk right now of being arrested and prosecuted for possession of marijuana.
Which is where the dope Yoda comes in.
Yeah, that's where we come in.
Yeah. Well, and let's be honest, there's a reason as we from this discussion, you haven't lost the title of Dope Yoda.
Still undisputed. No, but it's, I think that one of the things that this firm does differently is that we're not going to stop we're going to continue to broaden the horizon, make new arguments, because again, we're defending the client.
Well, and we don't quit.
Yeah.
That's the fun part about
Never quit.
it. And when going through this stuff, it's always going to be evolving. It's a moving target, but we got plenty of bullets that we like to, and we're going to use them, and we're going to defend the shit out of anybody who calls us their attorneys.
That's right.
Yeah. Well, appreciate you taking the time,
Yeah,
dropping
absolutely.
down the Yoda knowledge.
Lots of stuff to talk about. Lots of stuff in the funnel now too, and so I think that there'll be some more updates.
And I think we talked. We didn't get to it this time because this is a whole different loaded subject. But be on the lookout for an episode dealing with United States Postal Service.
Marijuana products through the mail.
Marijuana products through the mail, other types of products through the mail from out of country.
Customs and border protection.
Customs and border protections. There are a host of issues. We're going to keep you busy educating us on these different things because it seems like every other day there's a whole new problem. All right, man. Appreciate you taking the time to help us out.
Thanks for having me.
Keep working. Appreciate it.
We want to win. And if we can't win, if we look at everything and those elements are met, all right, how do we mitigate and minimize the long-term consequences to somebody? That whether it's getting a charge reduced, whether it's getting a probation as opposed to prison, there's a number of different levels on that scale if Plan A doesn't pan out.
Great. Rolling. We are back with a new and improved, additional, new and improved, I just said that, do's and don'ts with donut.
Wait, is it new or no?
It's a new one.
Okay.
It's a new one of yes.
Just wanted to make sure.
New. Something different. We just got done talking with the Dope Yoda.
Yep.
Brought him back, updated us. And before we go, I failed to mention in the news update that you had a birthday.
I did.
Like 21?
26.
Oh, my God. Yep. So birthday, 26. And then Madison had a birthday as well.
On the same day. What are the odds?
I don't know what the odds would be, but we had a fun lunch.
Yeah, we did.
We do birthdays right around here. So, new do's and don'ts with Donut.
Hopefully something that you're familiar with.
Uh-oh.
Can't read behind this.
I'm going to have to. This is a long one.
It is.
Okay.
We'll see if I can get through this.
We got this.
Okay. Title, got pulled over, blue 0.00, charged with DWI, and gave blood test. Blood test came back negative.
We call this a lawsuit.
Yeah.
Yeah. Okay.
Hey everyone, here's the story. I'm going to try to make it as short as possible. Left my parents' house after early dinner and was driving back to my place. Had 0 drinks at dinner and got pulled over around 6 p.m. The officer said I was swerving, but I told him I was just looking at my stereo. Tells me I have an odor of booze coming off of me and if I would submit to field sobriety test. I did the test and he told me I could blow into his breathalyzer. I did. He went to his car and came back and told me I was under arrest. In shock, I asked what I blew, and he said 0.00 and told me I was high and that my car now smelled of marijuana. He asked me where the marijuana was, and I told him I don't smoke. Never liked smoking as it's always made my anxiety worse. He searches the car, and nothing's found. I was taken to the police station to get a blood test and was booked into jail for 16 hours because they said I was not allowed to leave right away because I was high and had to come down off of it. The whole time, every police officer was asking what drugs I was on, and I kept telling them nothing. Finally get released the next day, and of course my family thinks I'm high now. They said police just don't arrest you for nothing, and I told them I did absolutely nothing, and how could I have done anything since I had just left their house? Flash forward to last Wednesday when I finally got my results back. Negative results on all 12 tests. Now that I proved my point to my family that I did nothing, I'm still really pissed off about this, and even though everything was dropped, it still makes me mad. I'm just thinking about how a police officer can get away with taking someone to jail for nothing. I was thinking to myself, if my friends had smoked weed a week earlier and the same thing had happened, they would still be charged with a DUI. Being 25 and knowing a lot of kids my age smoke weed, I was just wondering if this officer assumed I had cannabis in my system and was trying to get some quota, or just thought he could get me on some kind of drug charge to prosecute me. Is there anything you would recommend to me, or should I just forget about this altogether? That one's fully loaded.
That's loaded to the T.
Yeah.
So, welcome to the real world, kid. Like, this stuff happens. And
A lot.
people don't want to believe it happens. You know, law enforcement never lies. Law enforcement never claims to observe things that don't exist. We know for a fact it happens.
It does happen.
And soon, I hope we're going to have an episode specifically focused on police misconduct.
Okay.
Because that's exactly what that is.
Yeah.
Like, that's gross.
Yes.
But it happens all the time.
It does.
Where do you want to start with this?
I broke it down a little bit to make this
All
easier.
right. Thank you. Thank you.
Because it was a fully loaded one, and we got like 8 things we could touch on in that,
Yeah.
I think.
Okay.
Okay, so first one, he was stopped for swerving, and he immediately tells the officer that he might have been just looking at his radio.
At least it wasn't on his phone.
True.
Yep.
My first thought was, you don't need to justify anything.
Nope.
When they tell you why you were pulled over, or if they ask you why you think they're pulling you over, a lot of times they're just trying to get some sort of statement from you
100%.
to acknowledge that you were doing something wrong.
Correct.
But depending on what type of swerving in Iowa, that could lead to reasonable suspicion.
It could. Do ask for the damn video. Like,
Yeah.
I don't care if everything's dismissed. At that point in time, you send a request. What he needs to do, she needs to do, is send a request. You want every video. You want the in-car. You want the body-worn cameras. You want everything from the station.
reports.
You want the reports because, man, if they're saying they smell weed coming from the car, and clearly that didn't exist.
Yep.
They claim to smell alcohol. That didn't exist. What are the odds that weaving actually existed?
Exactly.
So, okay.
And
yeah.
he says he might have been looking at his radio, but
And-
that's not an admission
No.
that you were actually doing it.
No.
Second, officer says the driver smells like booze. Driver tells him he had 0 drinks, so he agrees to do, or driver tells us he had 0 drinks, so he agrees to do field sobriety tests, and then agrees to do a breathalyzer test. Cop goes to the patrol car, comes back, and tell him he's under arrest.
I'm assuming he did field.
Yes.
He or she did fields.
He did do fields.
This is exactly why we tell people there is zero reason to do field sobriety tests. The
Yes.
eyeball test, the walk and turn test, the one leg stand, the lean your head back with your eyes closed, touching your nose. There is absolutely no reason to do them. For most people, we can't do those on a good day, let alone with the stress and the anxiety of a traffic stop situation, whether there's booze in our system, anything in our system or not. What happens is when you do these exercises, law enforcement will use your performance on them, even if you blow zeros, to accuse you of being impaired by something other than alcohol. That's exactly what happened here.
Yep.
This is exactly what we caution people about every time we give talks, whether it's at a school, a business, or otherwise. We say, there is no reason to do them. You're not going to do yourself any favors at all.
Yeah, because in a lot of times, which I think is kind of funny, it's not funny.
It is.
But people say, I couldn't do that if I was sober.
No.
Like, that's not going to be interpreted in your favor. Even though if you are sober and you say that,
So
it doesn't seem incriminating, but you're literally saying, even if I wasn't drunk right now, I wouldn't be able to do this.
Rabbit trail. We do presentations at businesses. We do presentations at schools, high school kids. Every time I do one of these presentations, I put kids through field sobriety tests, high schoolers, not drinking in the middle of the day, hopefully, and they don't pass.
Yeah, you can fail them every time.
They don't pass.
Yeah.
I mean, I don't even have to be picky.
Yeah.
They suck at dividing their attention and doing these. They're not
Yeah.
gonna. You're not gonna do them on a good day. Don't do them, because all you're gonna do is give some BS justification. Hopefully, when this person sues the officer is gonna say, well, according to my training, if people can't do these field sobriety tests to standard, they're impaired by something, right? No alcohol. Okay, lose that. Well, it's got to be a drug of some sort. And what they're going to say later in the lawsuit is, well, maybe it was a drug that we just couldn't test for. There's
Classic.
always going to be an excuse.
Yeah.
So, yeah.
And
Okay.
breathalyzer, I've heard you give this advice multiple times. Always ask, if you agree to do breathalyzer because you haven't been drinking, ask the officer to see the results.
You want to see the results.
And that's your contingency for doing the breathalyzer
In
test.
Iowa, they don't have to show you the results. They don't have to tell you what it is. So you get them to agree ahead of time. It's only reasonable.
Yeah.
You're going to test me. I want to know how I do.
Yeah.
Show me the results.
Yeah.
And if they don't want to show you the results, then I'm not going to trust you to do a test.
Yep.
It's that simple.
The other thing I thought about Iowa being arrested, as soon as he tells you you're under arrest, that triggers your right to call or consult an attorney at a reasonable opportunity. They have to give you, ask for it. If they don't give it to you, it's just another thing to protect yourself.
Do ask. Don't argue if they say no, because
Yeah.
they gave you a hall pass.
Do ask, and do not throw a fit if they don't.
Nope.
Just let them
Be
forget.
happy.
Yeah. Okay, third. Cop comes back, tells him he blows zeros, and now claims that the car smells like marijuana and he's high.
Classic.
Happens, and you can be arrested for operating under the influence of marijuana.
Yeah, and proof. And so here's their. Well, I smelled it.
That's, yeah. Body
bullshit.
camera's great.
The body
For
cam.
everything other than smells.
Correct. The body camera does not disprove smells.
No.
You can't disprove the nostril. And so he's going to say, well, I reasonably believe that I detected the odor of marijuana. That's always going to be a fallback for these officers. But the fact, when you look at the, like they say, totality of the circumstances, the officer doesn't bring it up till later.
Yeah, until after he
Yeah.
blows zeros.
It's called
Yeah.
make believe.
Yeah.
This is backfilling, and but it happens all the damn time, and they're trying to justify getting that next test because that at this point in time, that officer is hoping to God that P test comes back with something in
Or
it.
the search of the car.
Correct.
Because that's what number 4 is. He asks where the marijuana is, searches the car, and doesn't find anything. So
Loss.
he's using the smell of marijuana to get into that car.
Because technically, I think there's an argument that the smell of marijuana coming from a car is probable cause to search the car.
Yeah.
Car is mobile. We have the vehicle exception.
Yep.
So he's claiming, there's making a claim, and then boom, disproved. Now, what they'll say is just because it's not there doesn't mean the odor didn't exist.
Yep,
right?
could have
There's
smoked it
always
before.
a fallback.
Yeah.
Always a fallback. Yep.
Gotten rid of it. Then he's taken to the station to have his blood drawn.
Mm-hmm.
How do they draw your blood?
With a needle.
Thank you. Dr. Bobby.
I'm here for y'all. I got this. Usually they make a written request, or a search warrant application gets made and gets granted, and then they have in Iowa, medical examiners show up and stick you with a needle.
And he didn't say, or he or she didn't say how this happened, but I would only assume that this person consented to it because they seem pretty steadfast in the fact that they're doing absolutely nothing wrong and want to go home.
And if you have
as soon as possible.
and if there's no risk of anything being found in your system, absolutely the way this person played this is absolutely the way you want to do it.
Yeah.
Because now you are going to have scientific proof that you didn't do a damn thing wrong.
Yeah.
And more importantly, scientific proof that what the officer is claiming is patently false.
Yeah.
So this is set up perfectly. If this was in Iowa within the last 2 years, call me, call us, right?
Yeah.
I mean, this is the formula for a lawsuit for this officer to get his or her butt sued, and for things to go in that file. So the next case that officer has, heard about the Giglio list?
Yep.
Right? That's the liar list, as it's called. Put that person on the liar list.
Yeah.
Because that's what's happening.
Because they'll do it to someone else, and someone else will be able to stop it.
You don't. It's like you never trust a thief because a thief never changes.
Yep.
You never trust a line officer because line officers don't change.
Fair. Lastly, booked into jail, and they made him spend 16 hours in jail.
Yep. We call that compensatory damages.
Yeah, we call that damages.
Yeah. And a lot of places will have that impairment. If impairment's suspected or part of one of the allegations, they make them sit overnight and see a judge.
16 hours is a long time.
That's a really long time, and that would be miserable.
I was thinking about that. Like, you get arrested at 6, probably all this happens. You're booked at 8, and then you're in there till noon.
Yeah, that's a long time.
That's damages. You're missing work.
You're missing work. Listen, photo goes up on the website.
Yep. Facebook.
Yeah, everybody shares it. Everybody's mocking you. Your family now thinks you're a stoner.
Are you in trouble because you missed work? Are you in trouble because you showed up late?
Yeah.
Are you in trouble because you got arrested?
You're losing your job over all this.
You have an arrest record.
Unfortunately, these things happen. So if we're saying do's and don'ts, do appreciate the fact that police misconduct occurs.
Yeah.
Innocent people do get arrested, do get accused, and even do get charged and prosecuted for offenses.
Mm-hmm. Innocent people go to trial.
Yeah.
All the way.
Innocent people go to prison.
Sometimes don't get their charges dropped.
Correct.
Yeah.
Sometimes innocent people go to prison. And
Yeah.
so we want to and we need to believe that this is an exception to the rule. I'd say by and far probably is. But it does happen, and you do need to know and exercise your rights, whether it's in this moment or after the fact.
Mm-hmm.
And don't let these things go.
Yeah.
So many people in these circumstances, when they finally get through with it, they're like, well, is it really worth it?
Do I just forget about it? Like he asked. Yeah.
Yes. And because it's easier to move on and not bring it up. If you don't do something about this, it's going to happen to somebody
Mm-hmm.
else. It's going to happen to multiple other people. So do something about it.
Yeah.
Do not forget about it and move on, because you're doing a disservice to the community. You're doing a disservice to the department.
Yep.
And everybody else that wears a badge that does things right.
Yep.
So that's a loaded one.
It is.
Like, we could have done a whole episode, and I think we've teed up now. We have now, from this episode, we're going to have about 3 spinoffs between drug stuff and now police misconduct stuff, which we haven't touched yet this year. And there's a few that
we have brewing in
we
the background.
We have brewing in the background that once we're able to talk about them, they are going to be, I think,
classic examples
Yep.
of things that need to change and improvements that we can make. So, summarizing this all up in do's and don'ts, what you got?
Do hire an attorney and see what you can do with your case, because you probably have a claim.
Yes.
At least here in Iowa. And the other thing was get that expunged from your arrest record once you can.
Get that expunged, and don't just forget about it.
No.
Fair. That's a good one, Sydney.
Yep.
I appreciate it. Happy birthday to you.
Thank you.
And rock on.
Cheers.
See you next time.
We can't change the past, but we will change your future. GRL Law. Thanks for tuning in to GRL Raw. Check us out at grllaw.com.